All right, everybody, welcome back to another exciting video here. We are going off my LinkedIn channel here. We are going to talk about vexatious litigant defined. What is a vexatious litigant? Many people think they know, few actually know, so I thought it would be time to go ahead and do a video on this, okay? So here we go. This is general legal information only. Attorney Steve here with you. Intellectual property technology lawyer. You need some help, you know where to find us. Mediation, litigation, and even some transactional work in there. Okay, so let's talk about it. This is under California law. This is general legal information only, not legal advice. This is just some information so that you can know more about what a vexatious litigant is than the next person, okay? So let's talk about it. Here's the code. Vexatious litigant means a person who does any, do you see that? Any of the following. So we've got four things down here. So if anybody does any of the following, they are a vexatious litigant. Generally means they file a lot of lawsuits for no reason. Okay, if you want to boil it down to the nutshell. But number one, in the immediately preceding 7-year period, they've commenced, prosecuted, or maintained improper. Now that's representing yourself, okay? Improperia persona is representing yourself in a litigation. So in the preceding 7 years, you've represented yourself at least 5 years, other than small claims courts. So in other words, municipal, superior courts, things like that. That have been, 1, finally determined adversely to the person, or 2, was unjustifiably permitted to remain pending for at least 2 years, blah, blah, blah. So point is, you've been in 5 out of 7 non-small courts cases, and you've lost, determined adversely to the person, okay? So in other words, it means you're bad at litigation. It means you're filing suits that don't have any merit. You may think they have merit, but the rest of the world doesn't think they have any merit, and so you're filing a whole bunch of suits and not succeeding, okay? So that could be deemed a vexatious litigant. That's probably the main one that I would see, but you also have this too. After a litigation has been finally determined against the person, it's a case over, repeatedly relitigates or attempts to relitigate improper, okay? Once again, they tend to repeatedly litigate. They can never stop. Okay, and so you can read the rest of that there. Number 3, in any litigation while acting improper, repeatedly files unmeritorious motions, pleadings, or other papers. So this is during a litigation. You're doing this, you're just filing papers, taking depots of anybody, subpoenaing all over the place, those kinds of things. So basically, if you're doing this kind of stuff, unnecessary discovery, or engaging in other tactics that are frivolous or solely intended to cause unnecessary delay. So the courts don't like things being delayed. They don't like frivolous things. You need to have a good faith basis for what you're doing. You need to actually be trying to resolve a real dispute. Okay, you know, I know that's not how litigation plays out sometimes, but you know, that's the basis of it. So if you're doing that, you could be declared a vexatious litigant. And finally, if you have previously been declared a vexatious litigant by any state or federal court of record in an action or proceeding based upon the same or substantially similar facts, transaction, or occurrence. Okay, so in other words, these are your 4 grounds. If you are dealing with a person in a court of law and they are meeting either of these 4 grounds, you can fill out this form right here. I've got it down here. It's your judicial counsel form. Okay, it's the V100. Let's see if I can open that up here real quick. Take a quick peek at that. But this is where you're filling out the form and you're saying, Judge, this person is a vexatious litigant. I don't know if this is going to show here. There it is. Judge, this person's a vexatious litigant. Here it is. You fill out the court. You fill it out. Boom. Court will label that person a vexatious litigant. Now, that person may come back and say, hey, wait a second. I have been a vexatious litigant. Yes, okay, fine. I'm coming to grips. But this case is real. This one's real. Somebody's infringing my copyrights. I've got this one for sure. So let's check that out. So there's a form for them to counter back and say, well, Judge, you know, yes, I've been a vexatious litigant, but I am requesting to file. Okay, and so with court permission, this person can be allowed, even though a vexatious litigant can be allowed to file. So there you go. So that's kind of how it works. There's an early motion to dismiss process if you're a defendant on the defending end of one of these shakedown lawsuits or troll lawsuits, or just somebody just trying to sue you for any old reason just to harass you, is basically what these is. There is an early motion possibility. This is under the California Code of Civil Procedure, CCP 391.1.2.3, and I even put .4 down there, okay? So here it is real quick. Any pending litigation in any court of the state at any time until a final judgment is entered, a defendant may move the court upon notice and hearing for an order requiring the plaintiff to furnish security, or for an order dismissing the litigation. So you can say, Judge, this is a vexatious litigant. We want this case dismissed, or we want them to produce some security once we win and prove it to be totally nonsense. We want to be able to exercise on that security. Could be whatever. Could be $10,000, could be $50,000, could be $1 million, depending on the case. It depends on the facts of the case, what you're going to be asking for as far as any security, okay? You're saying here, plaintiff is a vexatious litigant, and there is not a reasonable probability that he or she will prevail in the litigation against the moving defendant. So if you think that's possible, you can seek this early motion to dismiss. It's probably a wise idea, but again, will always depend on the facts of your case. 391.2, at a hearing upon the motion, such like this, the court will consider any evidence, written or oral, by the witness or affidavit evidence. That's a signed declaration affidavit under penalty of perjury. The court will consider these things. And again, down here, if after the hearing the court wants you, they can furnish for the benefit of the moving defendant security in such amount and within such time as the court shall fix. So that's where you go and argue for the big dollars. If you can get a big security, if the person cannot pay it, the case can be dismissed. Okay, there it is. Ordered furnished is not furnished. Litigation will be dismissed. So, this is one way to head off a litigation, is to get that amount set so high that the plaintiff says, geez, this isn't worth it, or I can't secure that amount. So that is litigation strategy here. Litigation Warrior, Attorney Steve Vondran here. Now, just for fun and frivolity, I would say, from Wikipedia, I got this page here. Some of the most notable vexatious litigants. I found some of this to be kind of funny. This guy here, he filed 40 separate frivolous lawsuits against the state of California, including one claiming cruel and unusual punishment after being served a broken cookie. Can you believe that? So he brought a constitutional claim under the 8th Amendment, which prohibits cruel and unusual punishment for serving him a broken cookie. Now, that really is something there. We got this guy whose actions led to the first British law against vexatious litigation, the Vexatious Actions Act, 1896. Schaffers became notorious after accusing wife of Travers Twiss, say that 10 times fast, of being a prostitute, and subsequently issued 48 proceedings against leading members of the Victorian Society. So that's what we call the shotgun approach, suing a bunch of people at once and seeing what happens. Down here, Indian chief, a Melbourne man, so declared after repeatedly suing doctors, insurance firms, and companies such as Carlton and United Breweries for smoking-related damages. However, note, on February 21st, 2006, the Supreme Court of Appeal gave him leave to sue Philip Morris, demonstrating that a vexatious litigant is not completely blocked from launching further court action. So every now and then, that, it's like a baseball player. They get 3 hits out of 10, and they're all-stars. In litigation, maybe that's true as well. So there are times when the vexatious litigant may just get up there and hit a home run. All right, we got another one, couple more for you, and we'll butt out of here. In fact, you can take a look at those if you want. I'm not going to take up your full day here, but copyright trademark trolls down here, filing a bunch of actions. You got all kinds of things. You got a Dorothy Squires, Francis Coyote Shivers, actor and singer, declared vexatious by the L.A. County Superior Court, 2008. Dorothy Squires, singer and former wife of actor Roger Moore, declared a vexatious litigant in 1987. So Church of Scientology's in here if you want to check that out. So, I mean, so there's all kinds of stuff. But that is more about Vexatious Litigant than anybody should know. And again, this can differ per your state, so look up your own state rules. But this is a general look at the California law. Hope you've enjoyed that. If you need more information, you can find me on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. Hope you like this. Make sure you subscribe to our YouTube channel so you don't miss any of the good legal clips we have coming out. We're now approaching 12,000 subscribers. 12,000. All right, everybody have a great day. We'll talk to you again. Bye now.